had a lot of people that RSVP'd for today. We can see people coming in on Facebook as well. So thank you for all of you who are attending live, especially. Of course, we'll do a recorded version of this, but a benefit that you have is that you get to ask questions with the live version of this.
And it looks like we got about 2 minutes until start time. So we'll take this opportunity just to say, hey, go ahead and if you have questions throughout this presentation, please feel free to use the Q&A function. You should be able to enter that at the bottom of your screen. Just see the Q&A button. We will address those for the most part at the end of the presentation, but feel free to ask any questions you have in that section and we will tackle them for you.
Great. Yeah, hopefully everybody can, this is a good time for technical stuff too. Make sure that you can see us, you can hear us, you can see the slides, all that good stuff. And again, Q&A is one of our best friends. We like to be able to get interactive with you instead of us just talking. Makes it a lot more fun, of course.
Absolutely. 29.
This is where you get the outtakes right before we hit the record button.
Right. Good stuff.
This. All right. Well, let's make sure that you can see us, you can hear us. Any feedback you've got along the way, I certainly appreciate that. And again, use Q&A.
So here we are.
And are we recording?
We are.
We are recording.
We're good to go.
All right. Great. Thank you for attending, everybody, whether you're here live or you're watching the recorded version. We like this because financial education is one of the things that we really enjoy, actually, as financial planners. So glad that you're here today. Today, we're going to talk about estate planning basics, meaning that there's a lot more that we could talk about, right, than just the basics. And it's a topic really we could, I mean, they have college courses on this, right? At Colorado State University, they have a whole semester long course on estate planning that isn't the financial planning major. So it's certainly not something that anybody is going to become a financial expert on the estate planning side today. But at least we're going to give you the flyover. We're going to address the topics, address the things that really you should be thinking about and we should be thinking about too. As we'll talk about, this is something that really impacts everybody when it comes to estate planning, not just rich people. So we'll definitely dig into that. We'll introduce ourselves. I'm Josh Nelson, the founder and CEO of Keystone Financial Services, certified financial planner.
And Jeremy Busch, certified financial planner. And I have other digits behind there too, but
and as you can see, we are live from the Keystone Financial Studios. So thank you for being here today. We always love to get feedback as well. So anything that you send us afterwards, as far as questions or maybe some topics that we didn't cover, that always helps us for the next time around, because we do this topic probably about once a year or so that we actually hit this one, because it is something that impacts a lot of people. So again, welcome. This is going to be a nice overview today of the estate planning process. And what we're going to talk about first, there we go, is really what an estate plan is. And more than anything, it's a map. And by the way, we're not attorneys. We're not estate attorneys. So this is something that you definitely, any of this stuff you should be talking about with your own legal counsel. But we are certified financial planners. And we know enough to be more than dangerous, right, when it comes to this topic, because we have not only the book knowledge, but a lot of experience. As you can imagine, number of years experience between the two of us, hundreds, probably thousands of different meetings talking about stuff like this. Not just talking about it, though, we actually see how it plays out when somebody is incapacitated or somebody passes away, whether that's our client or oftentimes it's the client's, maybe their spouse. Could be their brother, their sister, their parent. As you can imagine, we see a lot of stuff. We see a lot of stuff that works and a lot of stuff that didn't work out so well, probably not how somebody had planned. So the whole point about estate planning is that you're being very proactive, or we're being very proactive in our own estate plans. We want you to be very proactive as well, and thinking through what would happen if you passed away, what would happen if you became incapacitated, because more than likely this is going to impact all of us. Of course, death will, right, eventually, but even incapacity is pretty common at some point, even in very old age. So it's very, very important to be thinking about that. But overall, think about this as kind of like a map. It's something that you're leaving these instructions for somebody that you care about, that you love, or that's going to be handling your affairs if you're incapacitated or after you pass away.
Yeah, I think the key word there too is incapacitated, right?
Mhm.
Everybody has a plan, you know. I think a lot of people have wills that say, hey, when I die, this is what I want to happen. But an estate plan can go even further than that and take that into account. Like
Mhm.
if something happens to me where I can't answer the phone or I can't talk to my financial advisor, what happens at that point? How do I make sure that what I want to happen with everything, even with what I want to happen to me in that instance, is going to happen and happen the way that I want it? So
Yeah.
that's kind of how little things like that we can kind of help out with.
Yep, absolutely. And that would be the intro slide. So who needs an estate plan? As I mentioned before, it's not just for rich people. You know, rich, I guess everybody probably has a different definition of what that means. But I think when that topic comes up with a lot of folks, they think that it's something that really doesn't pertain to them because they don't think that they're wealthy or rich. It's not just for the wealthy. Without an estate plan, you really can't control what happens to your property. You can't even control what happens to yourself in a lot of cases. So sometimes it just happens to be the default choices, as we'll talk about, could work out fine and sometimes not so fine. But we want to be very purposeful about this as we're thinking about our own stuff. So an estate plan does make your wishes clear, helps avoid family disputes. That's another one that I'd say more often than not. And I'm sure we could all share stories, right? If you've been around long enough, you probably know because of a grandparent or parent or some other situation where even the family may have gotten along just fine. And then all of a sudden something happens to mom or dad and things get weird, right? It could be something to do with the money. Oftentimes we see it's not even the money, like the investments. Most people don't get emotionally attached to their investments, but they do get attached to the, the great grandpa's rifle that's been in the family,
Yep.
or something that,
Dad's classic car.
yeah, things that have been passed
Yep.
along, especially when there's only one of them. And now the three kids are all saying, no, dad wanted me to have that. So if
Yep.
you didn't have instructions in place, all of a sudden, very unintentionally, but now we could have a huge family dispute and people that aren't talking to each other anymore. At the very least,
Mhm.
awkward Thanksgiving, right?
Really awkward.
Yeah.
Yeah, this is
So-
a good way to avoid all of that.
Yeah, so we kind of say that in jest, but it does happen. And I think you all know that, right? Because you know situations, even if it's not in your own family, you know situations that have happened in the past. So really, it also will allow you to preserve assets and provide for loved ones. Really, this is about understanding the rules of the game. What I mean by that is the law. When it comes to probate law to estate law, there is a whole specialty around this. And that's why there are estate attorneys that's all they do is talk to people about this, actually write the documents, go to court when necessary. That's why there's a whole specialty out this that covers this because really covers this because it's so complex.
Absolutely.
So it's especially needed. So chances are, again, you probably need an estate plan. I can't think of many situations where people would not need an estate plan, but it's especially needed in more complicated situations. Say if your spouse isn't comfortable with financial matters, and that's pretty typical in a marriage. Usually one person takes the lead and is more interested in the money and the finances, and the other spouse is less interested.
I think we run across that one probably more than anything.
Yeah.
Is that there's always one spouse that is in charge of the money or wants to take care of all that stuff. The other one who kind of sits back and says, we're going to run with what
Yep.
I trust
They say,
you.
you got this.
You got this. I'll
Right.
take care of this over here.
Right.
And that's fine. But just to make sure that everybody's on the same page.
Yeah, at least from a 30,000 foot view, and again, conversations and things that end up happening. If one of the spouses is not in the loop, it's just not a good situation. So this is again, when everybody's healthy and living and everything like that, there needs to at least be a high level involvement by both spouses. And maybe there is still one person that takes the lead.
Yeah, at least to know that it's out there.
Yeah. But of course, if you have minor children, both of us have minor children. So if nothing else, that's why you need to have an estate plan for your minor children. Years ago, I ran into a situation that we had a client that they were the grandparents, but the daughter passed away, and very unexpectedly. And now all of a sudden we've got minor children, and we've got two sets of grandparents that are going after the kids basically and fighting it out in court. Just a horrible situation, right? I mean, just gut wrenching situation talking to those folks. So
Yeah, if
this is
anything,
yeah,
to do that for your family, to make sure that it's set up so grandparents don't have to worry about going through that fight and can just put all that information into those kids where it
absolutely.
needs to
And
be.
yeah, and making sure that people are willing to, right?
Yeah,
Say if I name my brother or something like that, what probably would be a good idea before having him be responsible for a bunch of kids. But it'd probably
absolutely.
be a good idea, even if it's not a financial issue, but make sure that he's actually
Make
willing
sure
to
they're
pull that
okay
off.
with it, or yeah, or if my brother was the default. I mean, love my brother, but I'm not sure I want him raising my kids. But
Yeah.
that's another story.
And you can name backups, of course, on all of these things, but it is important, again, if you've got minor children and understanding your family's wishes too. But I don't think it's outside of bounds to be visiting with your other family members. It might be your own children, making sure that you understand, hey, if something were to happen to you, it seems like usually it's when people are about to get on the plane to go to Mexico or something like that, they start thinking about their estate plans, right? And hey, can we get a will signed real quick?
And it's probably those conversations with other family members that, yeah, they can definitely be awkward conversations. And I think a lot of the time that's the kind of thing that gets in the way of people completing estate documents.
Yeah.
Oddly enough, is, they get hung up on, well, who is going to take care of the kids
Yeah.
if something happens to us? And then it's kind of a back and forth between spouses. Like,
Yeah.
I want my mom. No, I want my mom.
Right.
And so a lot of that stuff is where it gets in the way of actually getting the documents completed. But I think our take on this is it's better to have something rather than nothing.
Yeah.
And the key idea here is just because you have estate documents doesn't need to be, they have to be 100% perfect the first time. These are things that you can, redo, you can amend periodically as you go along.
Yeah, one thing that we will probably repeat more than once in this presentation is that because there is no perfect plan and because really something could happen to any of us at any given time, it's important to have something in place because the default oftentimes is not a good option. It's good to have some instructions in place versus none. And as long as we're living and have capacity, we can change them as often as we want to. So keep that in mind. So, and of course, in situations, this is a great problem if you've got this problem, right? But if your net worth exceeds the federal transfer tax exclusion amount, which we'll get into this more later on in the presentation, but everybody kind of has a coupon right now for about 12 million bucks. And what that means is that if you've got a $12 million estate or less, then your estate will not be subject to estate taxes. If you are married, you get double that amount. So keep that in mind that some of you this may apply to, or you may know people in your family that this applies to. So it's a nice high ceiling. Most Americans are not impacted by the estate tax, at least at this point. But of course, Congress can change this whenever they want to. So right now, it's not an issue. We don't see a lot of estate tax situations, but it very well could be in the future.
And if you are watching this and you find yourself in that boat, please come talk to us. We would love to talk to you.
Absolutely. And if you own property in more than one state, that's an important one. All of a sudden, now we're looking at multiple probates. If you own rental properties or vacation properties and say Florida, California, Oregon, and Colorado, and that's a great problem to have. Right. But now you're looking at potentially your loved ones having to deal and open up probates in all of those states, probably have to go hire attorneys that are licensed in each one of those states. You're talking about a potential nightmare. May not be a financial nightmare, but it could just be a logistical nightmare for somebody having to deal with them.
Yeah, and it can be costly to have to deal with that many probates.
Right. Yeah, yep. Exactly.
So,
and that many courts and so forth. So a lot of this is you're giving a gift to your loved ones really by doing this and making sure that there's a process in place. And of course, financial privacy, that could be a concern. Probate is a public process. So it actually goes through court. It's actually public record. Not that too many people are probably going to be spending the time to go look up how much my net worth is or something like that at death, but maybe, right? Or maybe it could be a higher profile situation. Maybe you've got a situation where you've got a celebrity situation or higher profile CEO situation in the family where you really don't want that information to be public. Maybe you're just private and you don't want that to go through public record. That's one thing to think about. And then, of course, if you own a business, that's a whole other thing. It's making sure that you've got a succession plan in place. In other words, how is that business going to operate going forward if the person that's writing the checks, something happens, right? They're incapacitated or they die. what happens now? Who can take over? And is there actually in writing a legal process that would make that happen?
Mhm.
So today we're going to cover a lot of different topics, and many of these we're going to cover quickly. We're going to do flyovers simply because we want to honor our time here and make sure that we don't go over the hour, because I know a lot of you are dialing in on your lunch hours here. We appreciate that. And of course, everybody's busy, right? You've got lots of stuff to do. So we want to keep to the hour. We're going to talk about planning for incapacity, healthcare, property management, planning for death, wills and probate, tax basics, lifetime gifting, life insurance, and trusts. It's like we're playing Jeopardy.
It did feel like
all the
Jeopardy.
topics. Maybe I could be the
I'll
host.
take healthcare for 200.
That's right. So planning for incapacity. Incapacity, of course, can strike at any time. Really, it's not just an older person's thing, although oftentimes that is the case, right? When people get older, they at some point probably are going to have some incapacity, maybe just at end of life. But lots of situations I think that we've all probably run across: accidents, people that get sick, all kinds of stuff that can happen. So we want to know that there's a plan in place if that happens. Failing to plan means a court would have to appoint a guardian. If you don't have any documents in place, now all of a sudden we're having to run to court, get a judge, and prove to the judge that somebody's incapacitated. That's not only costly, but it could be time consuming. And there may be decisions that need to be made that aren't getting made because we didn't have documents in place. Lack of planning increases the burden on your guardian. Of course, not only is it costly, it could be time consuming, but the people that are probably dealing with your stuff could be kind of traumatized, right? If there was an accident or something happened suddenly, if there's a loved one involved, they're probably emotionally going to be wrapped up in some stuff. And on top of that, having to run to attorneys and court and so forth. So this can help alleviate that.
Yeah, and in addition to that, their decisions might not be what you really want.
No.
You know, if someone gets thrown into that guardian position, all of a sudden everybody's asking them, you know, doctors, court representatives, what do you want to happen? What's this? What's that? And they have no clue what you want.
Nope.
You know, and that guardian, depending on what state you live in, can be two totally different people.
Yeah.
Because at that point, it's completely up to whatever the state's rules are in relations to this.
Yeah, it's important to name a backup too, which you can always do, because let's say that something happens to my wife and I, right? And to knock on wood, say there's an accident or something like that, and we're both incapacitated, or one of us has passed away and the other person is incapacitated. Now, if all we had done inside our documents is name each other and we didn't name a backup, we're still in the same boat, right? You still have the same problem because now we're having to run to court and so forth. So that's one thing to keep in mind. None of this stuff is pleasant to think about, by the way. So that's why a lot of people don't do it. In fact, I think the stat is that 70% of Americans do not have a last will and testament. It's that high.
Which is staggering.
Yeah.
Staggering a number.
Yeah. So that's just a recipe for disaster, as you can imagine. So making sure that you've got something in place, even if it's not perfect, is very important. So there are different things here, and it does depend on the state that you live in. We've got clients that are all over the country, living in different states, working in different states. So keep in mind that this is going to be specific to where you live. Probate process and estate law is a state by state process. So there's very little other than federal estate tax. There's very little that is going to be dictated from a federal standpoint. Important to note that if you've moved, you may want to go back and look at this, because you may have done your estate documents when you lived in Oregon and now you live in Colorado. It's important to have an estate attorney look at your stuff, make sure that it's still relevant. So living will, one of the things that you could put in place would be a living will that puts your instructions in writing. That is a healthcare directive that, and I'm just speaking from experience, if I look at my own living will, it's kind of a standard form in Colorado that is in the event that not only am I incapacitated, but 2 doctors have signed off saying that there's no chance of recovery, no brain activity. In other words, the only thing keeping this person alive is artificial nourishment, in other words. So that's when a doctor typically is going to ask the family for a living will. Do you have a living will? And that's going to say, yes, I would want to be taken off of life support, or I'd want to be kept going for a certain amount of time, or keep me going forever. So, you know, kind of the pull the plug document, to be a little crude about it, but that's kind of what you'd be thinking about at that point.
Absolutely. So, and then that goes hand in hand with the durable power of attorney for healthcare, not to be confused with the durable power of attorney for financial. They are 2 separate documents. So the healthcare power of attorney is one that lets you designate who you want to make decisions for you in that instance. So that these two kind of go hand in hand really together, I think, is that you put your instructions in the living will, and then you tell your healthcare power of attorney and say, hey, here's my living will. This is what I want to happen.
Right.
You're the one that gets to, give this to whoever, and et cetera.
Yeah,
right?
and it could even be a situation where maybe it's not end of life. Maybe somebody was in an accident or something like
Mhm.
that, and somebody needs to make a call basically on, what do we want to do here? Oftentimes the doctors are just going to do that, right? But sometimes there's actually a situation where maybe they would need to talk to a family member and get some guidance. So that would be exactly where that would come into play. And then a do not resuscitate order. And again, these are specific based off of states. These could be called different things, by the way. So if you're not recognizing the names of some of these documents, it could just be that your state calls it something different. But a do not resuscitate kind of sounds like the living will, essentially, in that you're asking not to be resuscitated, especially in situations where somebody's terminally ill. It's pretty typical that they would have something like that, that they would ask to, something happens to not be resuscitated. So it could be that you'd have one or all of these documents depending on where you live and your situation.
Absolutely. And then when we get to property, so yeah, it depends on how you own property. Again, so if you are a single owner of something, or if you own something jointly with somebody, that can even be different depending on what state you're in, if you're in a community property state or not.
Yep.
So you got to be aware of where you live and where you own property and what that state's rules are.
Yeah, absolutely. So there are different ways that you could designate things. One of those would be with joint ownership. And of course, if let's say you're married, you probably do own a lot of your stuff joint. You probably have the house and bank accounts and things like that are already in joint ownership. But you can also add a third joint owner. You could, if you're not married, sometimes people will do that. They'll say, well, I want to name my son or my daughter as the joint owner of a bank account. So, of course, one downside to that, potentially, depending on who it is that you're designating, they do have the same access and the same privileges that you do as owner of that account. So that's not always the best option, although it's pretty common, especially with bank accounts, that people just say, hey, it's simple, I'm going to do this, and that might work out fine for you. Durable power of attorney would be one other one, basically kind of like the healthcare power of attorney, but it's the finances. It's somebody designated. It could be the same person that you designated as your healthcare power of attorney.
Yeah, being financial planners, this is one that we see a lot, and we honestly love to have on file for just about every client in case of incapacity, because I think 9 times out of 10, if something happens to you, you're probably in the hospital, right? Which means hospital bills, which means some things got to get paid, things got to get taken care of. So if you're incapacitated and no one has access to your accounts on your behalf, technically no one can get at that money except you.
Yeah.
So these are really powerful things to have on set up. They can be set up a number of different ways too. I think a lot of people don't know that is that you don't have to name someone power of attorney and have it go live the second you sign it. There's a springing provision is what they call it. So a springing power of attorney basically says, I'm in control of everything until I become incapacitated. And at such time as I become incapacitated, this document becomes live. So that's one way around it. You might name your kid or something on there, and you don't trust them necessarily to look at your accounts all the time or whatnot. But if something happens to you, then they're the ones that can go there.
It's interesting talking to different estate attorneys. You can imagine we talk to a lot of different attorneys and accountants and other people, but there's different opinions on this. Some like the springing provision, some do not. Some say, you know what, it's kind of hard to prove. Essentially, say if your kid brings a power of attorney document into the bank looks at it, maybe something's happened to you. Well, now the bank says, well, we need proof that they're incapacitated, and now we need to go get a doctor's letter or something like that. So if you really trust the person that you designated as power of attorney, sometimes you might not have that in there. Of course, this is all personal preference, right, as far as how you would designate these things. And then finally, a living trust. We'll talk about this in a little bit, but a living trust, many people have these, many people don't. There's pluses and minuses, but it does let you name a successor trustee, meaning that you probably would name yourself as trustee while you're living. In other words, that's why it's called a living trust, is that you probably would name yourself, maybe you and your spouse as co-trustees on your trust until something happens, right? And then you probably have a successor trustee named, which could either be a human, right? It could be an individual, a kid, a friend, something like that. Or it could be that you name a corporate trustee, which could be like a bank trust department or a third-party trust department. We've got access to some resources there if you need to be able to name somebody or name an institution as a backup. We've got resources here at Keystone Financial Services that would help with that. One advantage there, at least having that as a backup, would be as of all the humans involved, maybe you're in a situation where you say, you know what, I don't really trust anybody to do that in my family. They're not able to, they wouldn't want to. We really want to name a third-party trustee. Of course, they don't do it for free, but to name a successor trustee, there's no cost until something actually happens. So sometimes that actually could be effective for you to at least name as a backup if all your humans kind of weren't able to serve, in other words.
Absolutely. So what does happen if you die without an estate plan? So really, we get this one a lot, I think. There's various types of property, things that we deal with specifically, investment accounts. Obviously, we talk to all of our clients about having proper beneficiaries on all their accounts. When you pass away, that kind of trumps everything, right? Those beneficiaries. So it's always good to keep an eye on those, make adjustments as needed if things are happening there. Otherwise, it basically has to go to what is called state intestacy laws. So if you die and there's no estate documents on file, it automatically passes through whatever your state's rules are about that. So it all goes through probate. The state government gets involved, the judge gets involved, and basically makes the decisions based on whatever that state's laws say.
Yep, and that might not be what you want. So intestacy means that you don't have any instructions. You probably don't have a will, in other words, or a living trust that had left those instructions. Kind of think of those things like a letter to the judge. Like a will would be kind of like a letter to the probate court judge, or a living trust would be a document that would be already in place. In other words, that would probably own a lot of your assets. So know that the laws are different in every state. Certainly something you want to speak with your own estate attorney on all this stuff, right? To make sure that it all jives with the laws. Just because you change states doesn't mean that you have to change your estate documents, but it is something to look at. But the typical pattern of distribution, whether you like it or not, is intestacy typically would be that you'd have the person, whether it's say the husband or father or the wife or the mother, they pass away. Oftentimes, state law will have only half go to the spouse and the other portions of it, the other half get split among the kids. And you might say, well, that's not what I want. I'd want 100% to go to my spouse and then the rest to go to the kids. Well, it's important that you put those documents in place to make sure that that actually happens. Otherwise, your state, the government, in other words, is going to decide where that money goes. And the ultimate beneficiary, by the way, is the state. So if you're in a situation where maybe you don't have a lot of family, especially say if you're old, maybe you didn't have kids or grandkids or something like that, eventually, if they kind of follow the intestacy laws and they run out of beneficiaries that are your blood relatives, it will go to the state. And you may not want that. Most people don't like that beneficiary option as far as the government.
Absolutely. And the important thing to realize on that one too is if the wife gets half and the children get a quarter and a quarter as it's set up, the court's not really going to care if your kid's 5 years old or if your kid's 50 years old. They have to follow those rules, right, as it's written in the state. And so, things to consider as you're going through just to make sure that your wishes are followed. Yep,
absolutely. So wills and probate, we talked about before, probate is the legal process, the court process that kind of administers your stuff, basically. So now you've passed away, right, passed away, and now assets are going to probate court that haven't been otherwise distributed. We talked about beneficiary designations, titling, doing trusts. There are ways that you can avoid probate, and some people want to avoid probate and some people don't. But will is the cornerstone of the estate plan. You always want one. You never would not want to have a last will and testament. So one thing to keep in mind when we say will, by the way, that means last will and testament. That's different than a living will, often confused. Yes. So again, this is the letter to the probate court judge, tells them how you wanted your property to be distributed. It does name your executor or personal representative. Sometimes you'll see that term depending on the state or the documents. And again, we talked about guardian for the minor children. It also can accomplish other estate planning goals, can sometimes minimize taxes. Very important to know the types of property that you own, especially retirement accounts, things like that can be heavily taxed if it's not planned well. You could also do this in multiple ways, believe it or not. If I wanted to, I could actually write out a last will and testament here on my notepad, and Jeremy could witness it. I could sign it, he could witness it, and that would be a legal will. So that would be administered to the court, and that could work out just fine. That's often not the best option, right?
They may have questions about that.
Yeah, they might,
Yeah.
and it might also be that the state's laws really needed more clarification, or maybe I wrote something down that's not even allowed, right, by law. So it's important to know that you could write it out by hand, but it's oftentimes better to either work with an estate attorney or at the very least use some type of estate software, estate document software that's been reviewed by attorneys.
Absolutely. So really the whole probate process. So, I think when you talk about this stuff, we always talk about probate, right? And avoiding probate as much as possible. So the probate process itself, I don't know if there's a 100% guaranteed way to avoid it completely, right? But the best way that you can do it is, like Josh said, have a last will and testament in place. Because if you die intestate or you don't have any estate documents, from that point on, it is up to the judge, it is up to that entire probate process to follow the letter of the law and run it out that way. That can be very time consuming depending on states. I know in the past I've had, relatives pass away who were, had to go through probate in California, minimum 6 months out there. I think Colorado is a little bit better than that, but probably not by a whole lot.
Yeah.
But the nice thing about it is if you do have that last will and testament, it is still going to go, that is going to be passed to the probate judge, but it speeds up the process dramatically. The judge looks at it, he says, okay, here's their instructions. Everything looks in order. Let's go ahead and run through this.
Yeah, as long as nobody's trying to contest it or something
exactly.
like that. Yeah.
As long as there's no contesting it, it flies through the process pretty quickly.
Yeah. Yeah, absolutely. So let's talk about pros and cons, probate pros and cons, because there are some pros. Sometimes people say, oh my gosh, I heard probate is so bad. Well, not always. One of the advantages is that the time and costs are typically modest. Not always. It depends on the state. In some states, the estate attorney, and this is so bizarre, but in some states, the estate attorney actually gets a percentage of your estate. So if you live in one of those states, you'd really want to make sure you avoid probate. Right?
Yeah.
You probably don't want the attorney to get any more money than they have to. Also, court supervision. Some people kind of like the idea that there's a judge involved, there's a court involved. Maybe it's a really contentious family situation or something like that, where literally you want somebody laying down the law.
Legal representation here.
Yeah, absolutely. Protection against creditors. That's one thing that can happen if you there's a certain amount of time, in other words, that creditors can come after your estate. Once that's passed, then they kind of shut the doors and away we go. That's why oftentimes you'll see notices in the newspaper or other publications because they have to publicly list. That's one of the things that the executor has to do, is publicly say that this person's passed away, to give those creditors time to be able to come after your estate, essentially. Now the cons, there are some cons. It can be time consuming for complex estates, like Jeremy mentioned. Title transfer delays, especially let's say you were trying to sell dad's car or something like that. Well, it could be because that could be a probate asset that you're not able to do that because you can't get the title transferred for a while. Again, there could be fees. Ancillary probate, it could be that something gets dragged on and on and on. So some people don't like that option. And of course, public record. Again, you might just be a very private person and say, you know what, I don't want any way for anybody to find out how much I was worth or what my property was worth. So that's valid, and if that's something that's important to you, of course, we want to look at that. So can you avoid probate? The answer is yes, in most cases, although sometimes it's hard to catch every single asset. So we talked about before, you can name beneficiaries, you can title things certain ways. You could have a trust, right? There are different ways that you can try to avoid probate, but chances are there's going to be something that you forget. Maybe it was a bank account. It could be just your personal property. If you have a few vehicles and just stuff, those actually would be probate assets if they weren't otherwise disposed of by one of these other ways.
Yeah, I don't know of anybody that has every single asset covered.
It's pretty
in-
tough.
Yeah, you always forget about something, but again, just because it's not necessarily listed, doesn't mean it has to be, long and drawn out, but it is the ways that, by listing specific things, if you have grandpa's rifle or
Mhm.
dad's classic car or
Yeah.
mom's sewing machine, and you know where you want those to go, there's ways to add those into your last will and
Yeah.
testament that just take all the question out of it and say, this person gets this
Mhm.
person gets that.
Yeah, there's usually a page, in fact, where you actually handwrite it in most cases. There's kind of a blank
Mhm.
page, and you kind of write who's supposed to get what.
Absolutely.
So sometimes we see that people will say, yeah, they kind of put mom put kind of duct tape notes to the bottom of things. Yeah, that might not be
I
the
have heard
most
that.
effective. But that could be one way that you kind of handle that stuff. Depends on your family.
Yep.
Yeah.
Yep. Owning property jointly with rights of survivorship. That's a huge one. Beneficiary designations. IRAs have to have them. You literally cannot set up an IRA without a beneficiary designation on it. Absolutely. Life insurance stuff. Yep. Trusts, if you have a really complicated, I think we get that one a lot.
Should
is,
I have a trust?
Should I
Yeah.
have a trust? Do
Yeah.
I need a trust? And so that's really kind of one of those, one by one, I would say
Yeah,
very personal
depends on your
things.
family.
It depends on your wishes. It depends on your family. It depends on, what kind of property you do own,
Yeah.
where your assets are. A lot of those play into, do you need a trust or does it make sense?
Yeah, it's usually for specific situations that we'll see that there needs to be a good reason, because you are kind of adding some complexity. You're probably adding some upfront cost if you're having an attorney draft up trust documents. So there really needs to be a good reason for it. In other words, I
Mhm.
definitely wouldn't trust anybody who just makes a blanket statement and says, well, everybody should have a trust. Well, not always, right? It depends on
Yeah.
the situation. And sometimes it has nothing to do with taxes or the complexity of the state. Sometimes there might be a special needs child, for example,
Mhm.
that really can't inherit the money. They need to have the money put someplace else and managed for them. Can impact their benefits that they would be eligible for. Certainly that they might be in a situation where they just can't manage their own finances or needs, but they do maybe have income needs or things like that would still
Absolutely.
need to be taken care of. So,
Absolutely.
of course, you could just give your money away. Right? Simplify all those steps. Just give all your money away.
Lifetime gifts.
Yeah.
I was in a meeting just the other day where we were talking about making those lifetime gifts. The
Yeah.
annual exclusion is up to 16,000 per person. It is a way to avoid some of that transfer stuff.
It sure is. So let's talk about taxes. And again, queue up any questions that you've got. We're going to hit these at the end because we want to make sure we get through everything. But transfer taxes, this doesn't apply to a lot of people, but it does apply to some. And again, this is a great problem if you have an estate that's that large. We talked about those limits before, but there is a federal gift tax as well. Back when the estate tax was put into place, I think in the early 1900s, there actually was an estate tax they put into place to tax, I think it was just a handful of estates at the time, probably the Rockefellers and the Carnegies and people that had $1 gazillion at the time. But of course, they got smart and said, well, I'll just give all my stuff away before I die, and then there's no estate tax. And so what they did is they put into place a federal gift tax that kind of matches up, says we've got the same amount of money effectively that you could give away during your lifetime or that you could give away at your death. That way you don't get off scot-free. During a really large estate, planning for that is something that's valid as far as making sure that we're addressing that. So the federal estate tax, again, is at death. Federal gift tax is while you're living. Federal generation skipping transfer tax, that gets a little bit more complicated, but again, that would be if you're trying to get funny about stuff and skip a generation and kind of avoid estate taxes being assessed on that generation, they will still try to get you.
Yep.
So keep that in mind.
Yeah, the important thing to remember about these is that, yes, the government's been through this because people have tried it before.
Mm-hmm.
It doesn't mean it's impossible to do. You can gift, like we were saying, you can gift annually every year $16,000 per person.
Mm-hmm.
Then you don't even have to file anything special on your taxes. If you go over that, you have to file a special form.
Yeah.
Generation skipping tax to grandkids, there are ways to do that. You just have to use the rules that are out there.
Yeah. As Jeremy said, $16,000 is the limit per year right now that anybody can give anyone. It doesn't matter if it's in your family or not. Jeremy can give me $16,000. I can give him $16,000, and there's no gift tax return. There's no taxes due. There's no government tracking, anything like that. And of course, some people ask, well, how are they going to know anyway? Right. And
Right.
well, the truth is, a lot of times they don't. There's probably a lot of gifting that ends up happening that the government never catches on to, but technically, this is the way it works. So $16,000, having that annual gift exclusion, especially if you're looking at your own situation and you say, you know what, it's very unlikely that we're ever going to spend all of this. Maybe we want to actually start making some gifts along the way, not only because it could help tax wise as far as lowering the amount of our eventual taxable estate, but also from a practical standpoint, it might be something that you're enjoying seeing your kids, your grandkids, whoever it is, use the money now, because they probably could use the money sooner rather than at your death. So a lot of times we do find that people do some gifting to be able to help out with that. Again, 12 million bucks is what you've got either for gifting or for an estate. But one distinction there to note is that the $16,000 annual gift exclusion is excluded. In other words, that does not count towards your $12 million. So anybody can do that every year, and you kind of get a clock that resets every year. So make sure that if it's something that's important to you, you're not skipping that.
Yeah, but additionally, that is one thing also for large estates that upon the death of one spouse, you can elect to transfer that to the living spouse.
Yeah.
I don't know that a lot of people, most people don't actually have an issue with that, I would think, but it is out there. So if that's ever something, that you need to know or that you're looking for, it is a possibility.
Yeah, you definitely don't want to leave money on the table, and especially if it's a family member, maybe you do have a parent or other relative that has a really large estate for whatever reason. Maybe they owned a business or they owned a ranch or something like that. And especially in an illiquid situation, which oftentimes is the case, where it is a business, it's land, these sad situations, right, where you find people end up having to sell, the family ranch that's been in the family for generations. They end up having to do that simply because the estate taxes are so large. So you might say, well, good problem to have, but it is a problem for certain situations.
Yeah. And that is, I'd say that's probably the biggest thing, especially, we live in Colorado, right?
Yeah.
And we have a lot of cattle ranches around here. And so that is definitely a thing, not a lot of free cash to be able to pay estate taxes, but a ton of money that's wrapped up in the ranch and in the cattle. And so then all of a sudden, dad passes away and now the kids may want to run the ranch, or one of the kids wants to run the ranch and can't afford to. And so they're forced to sell it basically just to pay the family
business. Yeah.
Right.
Yeah, absolutely. So it is real situations, of course, that we'd want to make sure you've got a financial planner, you've got an estate attorney, you've got a CPA, you'd have a whole team of people that would be involved in that situation. So basics around the estate tax, we are going to fly through this a little bit simply because a lot of people it doesn't apply to, but we do want to make sure we touch on it so you understand how it works. So again, the estate tax applies to transfers made at death. Doesn't matter what kind of assets they are, whether they're IRAs or property or whatever. They add up all your stuff, and that would end up being what you would potentially be subject to for the estate tax. Generally does not apply to transfers to charity, to spouse. There's an unlimited amount that you can give your spouse actually during your life and also at death, either way. So the spouse does not get hit with the estate tax, but both you and spouse pass away. Now, all of a sudden, that is kind of fair game for the government. Get charity, you can give away as much as you want to. So that's great. And that $12 million we talked about before. So any portion of the exclusion used for gifts will be unavailable to the estate. One thing that you should keep in mind.
And that's something that we could help anybody through on an individual basis, just because individual tax calculations, they can get pretty crazy. But for any more information on that one, just let us know.
Yeah, absolutely. Let's pause just for a second. I see a few questions coming in if we want to hit those while they're relevant.
Absolutely. So yes, this meeting will be available later. We always put the recordings for these out on our YouTube channel. So that will be out there. Absolutely.
That's easy to find, by the way. Social media for us is just on the upper right-hand corner of our website, keystonefinancial.com. All the little icons are there.
And let's see, maybe I missed you explaining it, but there was a mention about state transfer taxes affecting smaller states on the bottom of one of the slides.
Yeah, good question.
Can you elaborate?
Yeah, so if you've ever heard of an inheritance tax, and in Colorado, we don't have an inheritance tax, but the distinction there is the estate tax applies from a federal standpoint. Inheritance tax applies from a state standpoint. So if your state has an inheritance tax, it could be that not only do you get hit with a state tax, but you could get hit by an inheritance tax as well. Usually those limits are much smaller, by the way. So
Mhm.
it's much more likely if you live in an estate with inheritance tax, much more likely that you'd be impacted by that versus the estate tax.
Absolutely.
Good question. All right, federal estate tax. Jeremy mentioned this before. Portability. This gets really kind of wonky and in the weeds as far as planning, but now we do have portability on the spousal election amount. So we talked about that $12 million coupon that we all have either for gifting or passing on at death. Keep in mind that that amount, there used to be really exotic estate plans that people would devise because you would kind of lose that. Let's say in a situation in the past, before they changed the rules, say something were to happen to me, I pass everything on to my spouse, then my $12 million, because I left everything to her, right? My $12 million kind of coupon would have just gone poof, gone away. Then if she passes away, now she's only got $12 million. Again, situations that would be great problems if you really had a $12 million or $24 million estate. So we laugh about it, but again, a lot of times in situations where it could be family ranch, family property, business, something like that. So now you automatically get the ability to have portability. In other words, same situation, a large estate. If I passed away, now I would have that $12 million automatically give to Sarah, and then Sarah would have up to $24 million that she could pass on.
The important thing to remember on that one is if you're interested in the portability, it is an election that you do have to make upon death of one of the spouses. So it is an active election. It doesn't happen automatically. But something to consider. Keep in mind.
So make sure you're working with experts that know what they're doing. Otherwise, it could be really costly in certain situations. So again, $24 million, you could leave to beneficiaries tax-free from an estate standpoint. So let's talk about the generation skipping transfer. Again, very quickly, this is for somebody who's trying to skip a generation, pull one over on the government and say, hey, we're trying to pass this on. Skip some generations where they normally would have gotten hit with the estate tax. They do catch that. So there is a $12 million exemption, same amount, right? So that
same exemption. Really, the whole reason this exists is because people did it in the past. Right, and the government missed out, and they said, "Nope, nobody's going to do that to us again."
Some smart estate attorneys that said, "All right, let's try this," and then they figure it out. So that is not portable, by the way. That's a one-time deal. So you don't get to pass that on to another generation or to a spouse. So looking at the chart here, you can see that these numbers are pretty consistent. These numbers do go up. They are indexed to inflation, by the way. So each year, the exemption amounts, the $12 million coupon that we all have right now, it's going to go up a little bit next year. I'm not sure if those numbers have come out yet, but about right now in the fourth quarter, typically we'll see what those new amounts are. So keep that in mind. Top estate tax rate now is 40%. In the past, it's actually been much higher than that. It's been up in the, I think 50-something percent, 60-something percent historically. So again, it's a good problem if you've got this, but it's at a historically low rate right now. Gifting, we talked about that a little bit. Again, one big side benefit is that you get to actually enjoy seeing the recipient be able to use the gift, right? So it could be that you're using it to help them with college. They could be using it for maybe helping their own kids. Maybe it's helping them buy a first home. There's lots of things that you could be passing that on for. And a lot of times it is our clients that we get into situations, we do some good planning. We figure out, it's really, really unlikely that we're going to use all this money during our lifetime. It's probably going to be money that we'd be leaving to somebody at the end. And maybe we would rather not do that. Maybe we want to have money at the end, but not quite so much. And we'd like to do some things along the way.
Yeah, and I think a lot of people get a lot of satisfaction out of this, a lot of personal joy, when you can do that gifting and you can see them using that and enjoying it and maybe starting a business or whatever it is, right? And just fantastic to see the looks on people's faces when they're able to do that.
But we get to see some of those looks too, because a lot of times it's a surprise that, hey, we're going to start doing this gifting, or maybe you just did it once, right? 1 year, or maybe you do it every year. But a lot of neat situations we're able to see. So that's one way you could do it, is that you could give the $16,000 per year away. It does remove the appreciation too, of course, because it's not yours anymore, right? So it removes the appreciation that you would have had on that $16,000 for the future as well. And then one downside potentially is that there's no step up in basis. So one thing to be careful about, let's say that you aren't going to give cash. Let's say you're going to give your kid some Apple stock from maybe you bought it in 1980.
Yeah.
That would have been a really nice time to buy Apple stock if you held on to it. So clearly it would be a highly appreciated asset. If you were to pass that on to anybody, maybe your kid, now instead of them receiving a step up in basis upon your death, now all of a sudden they inherit your basis and they turn around and sell the stock, they're going to have to pay capital gains taxes on it. So
I think we see this one mainly with any kind of property, like Josh said, Apple stock or vehicles or
a house,
antique furniture, any of that stuff. All of that stuff counts as that no step up basis property.
Yep. Yeah. And some situations we've seen in the past where sometimes we help people dodge a bullet, right? Where maybe we've got an older relative that owns property in Southern California that they've lived in for the last 50 years. Right. Big appreciation that you have in that property, more than likely. So it could be that they have good intentions, right? Well, I'm just going to sign the title over to you. Well, if you do that, you could do that.
Wait on that.
But now all of a sudden you just completely missed out on, you're going to subject to all that's capital gains essentially. So be very careful about that before you actually make those moves. Make sure you're working with somebody who knows what they're doing, in other words.
Yeah, all of this stuff basically comes down to plan ahead, right?
Yeah.
Don't make decisions like this. Yeah. Don't make decisions like this because, that'd be really nice if we did that. Talk to a professional beforehand, even if it's not us, talk to a professional beforehand because you can save yourself a lot of money and a lot of hassle, and not even just yourself, but your family members along the way by knowing the rules and doing it the smart way.
Yeah, because again, the beneficiary of all of this, if you don't plan correctly, oftentimes is the government in the form of them getting your property, or they get part of your property simply because of taxes that maybe weren't necessary. Maybe you're getting hit by taxes that with proper planning, you could have completely avoided. That step up in basis is one that impacts a lot of people, not just wealthy people or rich people or people over that 12 or $24 million. That really impacts everybody.
Absolutely. So again, transfers excluded. So we're back to that 16,000 for individuals. Other ways of excluding is 529 contributions. So for any parents or grandparents, a lot of that we know and deal with all the time, contributions to 529 plans. Really great way to make sure the grandkids can go to school in the future. A lot of flexibility with those as well. Another things you can do is anything kind of along the whole school thing, anything paid directly to the school itself. I think a lot of people don't realize that is, if you pay it to your grandson or granddaughter, yes, that's a gift. If you pay it directly to CSU, that doesn't get included. Nope. That goes straight to the school, doesn't get included as that 16,000 exclusion, any of that stuff. So there's smart ways that you can go about this if you have specific goals. Yeah,
because maybe you don't want to make a 529 contribution and have that eat up the $16,000. Right? You may want to give that to them because it's for their first time home purchase someday, or for some other purpose, right? That you want to have them be able to start a business or do something else. You could actually make the contributions directly and then to the institution, and then there on out, go ahead and gift them the $16,000 or $32,000, as we mentioned here. Let's say that I made a $32,000 gift right now to one of our kids, and I just wrote the check. Right. And again, you say, well, how would anybody know this? Well, they probably wouldn't, right? Unless you get audited and somebody really digs into your stuff, right, from the government. But ultimately, they would look at that and say, all right, but you're married. So it's $32,000 is the limit, even though technically it was me that wrote the check.
Yeah. Law is the law, though. And then same way with paying directly to I think you put up there.
Go
the other direction. Yeah. Same way of paying it directly to the school is if you pay it directly for medical care to the medical institution. So hospital bills, doctor bills, things of that nature works the same way, doesn't get included, but gets the money out of your estate.
Yep, absolutely. And hopefully we wouldn't have catastrophic medical expenses, but sometimes there are things that aren't covered. Right. It could be a situation where it's some kind of experimental treatment or something like that that the insurance won't cover. It could be something that you're just paying for it directly. trusts. So let's talk about trust because this comes up a lot. Probably one of our most common questions we get from clients is, should I have a trust? I heard my best friend said everybody should have a trust. Not necessarily. It's very situational. We talked about this before. It can be a great tool. There can be a lot of good things that trusts do. We've also seen situations where people come in, maybe they hadn't worked with us before and we're looking at all their stuff. They come in with this big thick binder of documents and they say, well, this is all my stuff, my trust and everything. And we dig through it and figure out they've got a living trust that they probably pay thousands of dollars to have somebody draft. And then we ask them, well, what property is in the trust right now? And they kind of give us a blank look.
Yeah.
And as we
It's
dig
never been
into
funded.
it, we figure out that, yeah, we never did anything with it. We never
Mhm.
changed our title of our property or stock or accounts. So it was kind of really expensive paper.
Yeah, so the places where a trust is, I think, the most useful that we
Mhm.
found is if you have, complex instructions. Basically, I want this kid to have this, but this kid not to have anything. Or Josh had mentioned earlier, if you have a special needs child or family member who needs care, that's kind of the things that would require a trust, because that needs to be set up to say, someone's going to take care of this. This is who they are. The more complex your situation gets, the more likely it is that you would need some kind of trust.
Yeah. And some people hate them, by the way. I've had clients before that
Mhm.
they set up a trust, or maybe it was that their parent had a trust and then maybe the kid was responsible for kind of sorting everything out after mom died. Sometimes they end up being a lot of burden actually, and a lot of complication that comes into it. So it's not to say that everybody should have one. It's also not to say that you shouldn't have one, right? It's
Mhm.
just a tool. Like all these things, it's a tool.
Absolutely. And then what is a trust? Really, it is, a legal entity. So the parties to a trust, the grantor, the trustee, beneficiary, grantor, and trustee, a lot of the time, I would say, are the same person. They can be different people. There's difference between a living trust or a testamentary trust.
Yes.
Testamentary basically means it only goes into action when you pass away. Living trust is it's there while you're alive.
Right. And some people like that. Some people like the fact that, I can kind of settle my affairs in advance. Right. And again, you're probably not going to catch everything. You're probably going to have vehicles and stuff and something that would have to go through probate. But people sometimes like that. They say, no, this kind of makes sense. And so that's fine.
Yep. And then revocable versus irrevocable. There's about 1 million different ways that you can write up a trust,
Yep.
Depending on how it is. If you want to make sure that X amount of dollars are not included in your estate when you pass away, you would need something that's irrevocable. Differences between those two, but basic high level view is trust can get complicated rather quick. So this is best to kind of talk to a professional if you think a trust is in your future and what that might look like.
Yep. And sometimes, again, it could be specific situations. It could be that maybe you've got a child that has had a drug problem, for example. We've run across that before, where maybe there's 3 kids and one of them has had issues, right? Sad, right? But it could be a situation where that would be a disaster for that kid to have a pile of money dropped in their lap with no kind of supervision or controls on it. So that could be where that trustee comes in handy.
Yeah, absolutely.
Yeah.
And then, of course, how does life insurance play into this? So this is one kind of going back and where I can see it, or where we have seen a lot of this, I should say, in our area in Colorado, there's a lot of ranchers, right? And so one way that these ranchers, they know that so much of their money is tied up in the ranch and that the kids probably wouldn't have the available cash to pay any estate taxes.
Yeah.
How do you get around that? You can use life insurance contracts for that. When life insurance typically pays out, it usually pays out as a tax-free benefit.
Yeah, income tax-free.
Yep, income tax-free. There you go.
Yeah.
That pays out, and then the kids can use that to maybe pay estate taxes, or a number of different ways that you can use this. But it's another tool in the box.
Yeah, I throw that out there, the income tax-free, because as you can see on the slide here, we mentioned estate tax. That still applies. In other words, you may have a tax-free thing because of a step up in basis or because life insurance pays out income tax-free, but it still would be included in that gross estate unless It's in an irrevocable life insurance
you go.
trust, and that's oftentimes how these ranchers will do it, right? There's kind of a loophole that's still available that allows us to actually set up an irrevocable life insurance trust, funded. So it'll be a life insurance policy. There's an insurance company involved. There's beneficiaries that have been named. And so it's a little bit complicated, but more or less what it allows you to do is make annual gifts into the irrevocable life insurance trust. What it does is it provides a tax-free death benefit that's held outside of your estate. So technically, you actually are making gifts into the trust. Beneficiaries technically could take their money out if they wanted to, but of course you would sternly tell them, don't do that.
Don't do it.
Right?
Yeah.
But they could if they wanted to. And then finally, the trustee uses those cash gifts to pay the premiums along the way. Works out just fine as long as those beneficiaries don't dip in and start taking all the money out. Then, of course, there wouldn't be any money to pay the premium. So this would be a good family conversation, right? To make sure that, and they do have to be informed, right? The beneficiaries do have to be informed that they have the right to be taking it out
every year.
So yeah, good family discussion to make sure that everything works out well. So at death, then the insurance company basically pays out that beneficiary. The trust receives it. It's outside of the estate, so it's not subject to estate tax. Again, this is something we're seeing with really large estates typically, or it could be very illiquid estates. Oftentimes that's the case. It provides a bunch of cash, basically. That's one thing that life insurance is really good at, is it pays out a bunch of cash.
Absolutely. So I think the basic idea here is that, yes, there are tools in order to accomplish a lot of this stuff. Do they make sense for everybody just to avoid, some taxes or whatnot? Probably not, for the amount of tax that you would avoid versus the cost of setting one of these up.
Right. They're expensive.
But for anybody, there are all these tools out there, which I think is ultimately why it's best to talk with a financial professional whenever you're considering these, just to make sure that you're not paying for more than you need in the area of estate taxes, but you're still getting your wishes set forth and ensured that that's going to happen.
Yeah, it's a tool like anything, like a hammer. A hammer's not good or bad, right?
Right. It depends on what you use it for.
It's just a hammer, right? In certain situations, it can be very useful. So as we conclude here, we're right at the hour, so we want to make sure we got through the content portion of this until we get to the fun part, is the Q&A. And by the way, I think Doug told us that the exemption amount, he looked this up for us. Thank you, Google. The $12.92 million is the 2023 estate tax exemption amount. I think those were just released this week, up from $12.06 million in 2022. So keep that in mind. And then another mention is that life insurance is income tax free unless it is annuity life insurance. That is true, by the way, that annuities are, even though it's issued by an insurance company, those are taxable at somebody's death. Life insurance is not. So that's one distinction to be aware of. So as we conclude here, a few questions to ask yourself as far as kind of next steps. Number one is, have you implemented a plan for incapacity? That would be things like powers of attorney, DNR orders, living wills. We talked about that. Do you have a valid will? And again, we're talking about a last will and testament, that letter to the probate court judge. In other words, are transfer taxes a planning concern for you? In other words, do you have a very large estate, or is it someplace in your family? Maybe there's a very large asset that could have some estate tax implications or inheritance tax implications. And then ultimately, does your overall estate plan reflect your current wishes and circumstances? And I'll kind of leave it with that, because I think that's really what this is all about, is making sure if something happens to me, I'm incapacitated or I've died, what would I want to have happen? So when I'm putting these documents in place, or Jeremy or Sarah, my wife, as we're putting these documents into place, you have to have it from the perspective that something could happen to me today or tomorrow. So as I'm putting this into place, it may not be that I have all the answers right now, but these are the answers that I would have if I knew that something was going to happen tomorrow. That's really what you're deciding right now. You can always make adjustments as time goes on. I tell you that just because it's something we see a lot, where people, they know they should get their estate documents done, but they do get stuck. They get stuck on a question or an issue, and then they just don't do anything. So don't do that. You want to be among the 30% of the population that has an estate plan, 30%, right? Yes,
absolutely. And it's such a good feeling too. If anybody out there who does have estate documents in place, once you sign that and you make them official, it is like a weight.
Yeah, especially if you're getting on an airplane,
right? To say, hey, it may not be perfect, but I got it out there, and I think it'll happen the way I want it to.
Yeah.
So.
Yeah. So don't wait until you're going to jump on the airplane to Europe or something like that. Although sometimes you can get things done quickly, it's
Right.
better to think about this in advance. We'll get into Q&A here, so feel free to throw that out. We're going to be looking at our Q&A. As we do that, we also want to make sure that we are properly informing you of what we actually do at Keystone. And we like to say that we make the complex simple. If you didn't believe that this stuff was complicated before we started today, you probably do now. And this was the basic version, right? This isn't the advanced
Absolutely.
version. That's coming, right? So the advanced version gets into a lot more details. But as you can see on our chart here, I know these boxes are kind of small depending on your phone or your computer screen, but we get into what we call comprehensive financial planning, which means we're looking at all the different areas of your finances. It's not just about the investments or the market. It's not just about retirement planning. People have different situations, and of course, things are going to change in your life and your family over time, your career. If you're changing jobs, you've had family members pass away, you retire, your circumstances are going to constantly change throughout your life. So that's what we do with our clients is we walk alongside them. We're your fiduciary. That means that we're your trusted advisor. We've got a legal obligation to act in your best interest at all times. And we give you advice that's not just about the investments, but everything that pertains to your planning. So that's really what this shows. This busy chart here shows you all the different planning areas that we could kind of think of when we put together the chart, but it's a lot. There's a lot of stuff that happens, and we want to make sure that we're here to plan with you.
That is also available that we could send to either electronically
Yep.
or via paper if anybody's interested. Just let us know.
Good point. We're here. Our team is here to serve you. We've got a lot of different situations that come up. And the fun part about what we do is that we get to genuinely help people. And sometimes it's ways that are quantifiable, sometimes not. During markets like this, economies like this, sometimes it can get really emotional and people aren't sure what to do, right? So it may not even be about dollars and cents. It might be about some advice about how to set up their estate stuff. It could be things related to their work, or can I change jobs? Can I retire?
Can I retire?
Yeah, that's
that one
that's
comes
a
up
big
a lot.
one. Absolutely.
Yep.
So we've got a whole team that is here to serve you. 3 of us are certified financial planners, which is the gold standard when it comes to the financial planning industry. So that being said, what questions do we have?
So we do have one more. Do we have recommendations for professionals to help with estate planning?
Yes.
By all means, we do. We have a few. We have local ones that we can often refer to people as well. If you are interested, just shoot us, either one of us, an email. Josh at keystonefinancial.com, Jeremy at keystonefinancial.com, and we can make those personalized recommendations for you.
Yeah. Yep, absolutely. And I will say that even if you're not in Colorado, we know attorneys that are based here, but we're networked across the country. We know financial professionals through the Financial Planning Association, through the Certified Financial Planner Board of Standards. We've got a lot of contacts. So if you live in Louisiana or some state that maybe doesn't have an estate attorney that you're comfortable with, let us know. We can help you track somebody down that would make sense for you. Our contact information is up here, by the way. As Jeremy said, you can shoot either one of us an email. We try to keep ourselves pretty available, right, to get answers back, especially if you've got something urgent going on too. We do have locations now, primarily our clients, if you were to say, where do they live? Most of them live in Colorado and Arizona. Those are our primary 2 states, but we do have clients all over the country, Florida, Washington State, California, Florida, kind of all the corners, New Hampshire. So it's definitely fun for us to continue working with you regardless of where you're at, but also know that we're here for your family. We're here for your friends, your coworkers, anybody who's confused about this stuff. In other words, needs a good planner that they can trust. Really, that's why we're here.
Absolutely. That's what, and that's kind of our role as, financial planners, is because we have those CFP guidelines. There is, we're a lot more about the education, I think, than anything. Even if you never become a client, we'd rather help you prepare than have to repair later on in life.
Yes, well said. Yeah, we are here to help people. Obviously, we're a business. We need to make money, right? But we are here to help people. And we do pro bono work, on a pretty regular basis in situations where it might be somebody's kids, it might be their grandkids, it could be somebody that they don't have the financial resources to be able to be able to hire an advisor. We love sitting down with people and kind of helping them get started and getting them pointed in the right direction. As you can see on the last slide here, this is our disclosure slide that we need to tell you that everything we just talked about is our opinions. And so it's very important to consult your own financial advisor, your own tax professional, your own estate attorney, and we are here to be able to support you in any way that we can. Any questions?
Last one's not really a question, but
Yeah.
thank you, Rhonda, for submitting that. Just saying that she's used one of the referrals that we had, and like many other of our clients, has had a good experience with that and was happy to get that knocked out. So,
yep, absolutely. Yeah, thank you for your business. As always, thank you for your support, your business. We enjoy working with all of you, and certainly appreciate the referrals you send our way. We've actually grown more this year than we ever have in Keystone's history as far as new clients, new assets coming in, which you might say, wow, that's crazy with the market being so bad. But that's kind of why. There's so much uncertainty right now that a lot of people, whatever they were doing before, they're kind of questioning it. And I think that's what we're seeing. They're kind of questioning their plans, or knowing that, hey, we just need some guidance. We need to look at this stuff with somebody that we can trust. So thank you for that. Thank you for sending people our way. And yeah, I think it's a great way to wrap out the presentation here as we're talking about estate stuff. Sometimes not the most happy topic to be thinking about these things, but nonetheless very important. So
absolutely. Thank you to everybody for showing up today. If there is anything that didn't get covered in the Q&A, or you have other questions beyond that, please reach out to us individually, and we would be happy to talk to you about that.
Yep. Thank you. Take care.
Bye.
Bye.